This is Nick Fellow, and I'm coming from you today from Ackerman's Washington, D.C. office. Now, I'd like to give a brief explanation of the Association of Proprietary Colleges up in New York and their gainful employment lawsuit against the Department of Education. As many of us will know by now, on Wednesday, May 27th, Judge Lewis Kaplan of the Southern District of New York dismissed APC's motion for summary judgment, while at the same time granting the Department of Education cross motion for summary judgment. Essentially, this dismisses APC's claim and challenging the gainful employment regulations. Why? The three reasons that Judge Kaplan gave are: first, APC had no due process protections in the Title IV eligibility. Second, the department was within their statutory authority to promulgate such rules. And third, the rules were crafted within the confines of the Administrative Procedures Act. Looking first at the due process claim, the APC argued that they had a property interest, therefore required the proper procedures to challenge such regulations. However, Judge Kaplan said that these schools have no vested right to future eligibility to participate in Title IV programs because the schools are not promised or even led to believe that they would have no background or other eligibility changes as issued by the Department of Education. Furthermore, schools are not the direct beneficiaries of Title IV funding, rather that would be the students. Further, to dismiss the property interest, the Higher Education Act allows for the department to have latitude and the ability to decide whether to change the eligibility to a particular program, and furthermore, there are other statutes besides the Higher Education Act allow for the department and other agencies to issue regulations that may limit, suspend, terminate, or terminate an eligible institution's participation in such programs. In terms of a liberty interest, schools have an opportunity to protect their good name, and specifically if the name is being tainted by the government, then they have a right to a hearing. However, here APC never necessarily proved how the rules would be proven false and that the department and the government were disparaging their names, nor do they show how the rules would be derogatory in any ways. So even if the schools had such liberty and property interest, Judge Kaplan ruled that the due process claims would fail because schools have the opportunity to challenge the regulations, specifically the metrics. For example, though, the touchstone of due process is that the requirement that a person in jeopardy of loss be given notice of the case against them and an opportunity to meet it. Judge Kaplan determined that the rules provide a school an opportunity to correct the department's list of completed students, an opportunity to challenge the accuracy of the loan information, and then finally the ability to file alternative earnings calculations, all in a way to challenge the metrics and the school's position in terms of gainful employment. One of APC's strongest, or so they thought, arguments was the retroactivity aspect of the regulations, specifically that the metrics were going back as far as 2005 and using information that was in some cases 10 years old. However, Kaplan ruled that the regulation is only retroactive if it alters the past legal consequences of past actions, or if it would impair rights of a party when he acted, increase a party's liability for past conduct, or impose new duties with respect to transactions that have already been completed. Here, because schools don't necessarily have to pay back any loans, or that they're not going to be in further legal trouble, if you will, for their past actions. This is all creating new material. Moving then to the statutory authority claim, again, Judge Kaplan ruled that the department was in their statutory authority under the Higher Education Act to promulgate the rules. Here, Judge Kaplan believes that APC makes a similar argument than what ASCU made in their 2012 challenge of the 2011 rules. Therefore, Judge Kaplan believes that there was no need to replow old ground, and then he quotes at length Judge Contreras, who heard the 2012 APC challenge and ultimately dismissed and vacated the rules, but granted APC's motion and dismissed those 2012 rules. But nonetheless, in Judge Contreras' opinion, the department was able to act under the statutory authority, and therefore, instead of replowing that old ground, Judge Kaplan here in New York decided to quote at length Judge Contreras' opinion. For those who may remember, there's basically three options here, or three reasons. First, that there is no unambiguous meaning to what makes employment gainful, and that the phrase need not mean any job that pays. Second, that the structure, purpose, and legislative history of the Higher Education Act does not unambiguously foreclose the agency's and the department's interpretation of what gainful employment means. And then finally, that gainful employment regulations are a reasonable interpretation of an ambiguous statutory command. Another unique claim that APC had compared to their APC claim, or the current APC claim, is that it went beyond or sapped the power of the accrediting agency. According to APC, the rules would limit what the State Board of Regents would have in terms of accrediting these schools up in New York. Unfortunately, Judge Kaplan disagreed. He said that the rules say nothing whatsoever about the content of the educational programs, but rather they are only concerned about the quality of those programs as measured by the graduate's ability to repay their loans. While federal law prohibits the department from dictating state schools and their curriculum, the department is allowed to condition the school's eligibility for federal student aid programs on performance-based metrics that do measure the student successes. Moving now to the legislative history, APC argued that the legislative history shows that Congress did not intend the department to deny Title IV eligibility over program quality. While Kaplan acknowledges that the legislative history is often murky, ambiguous, and contradictory, he does note that judicial investigations into legislative history has a tendency to become an exercise in looking over a crowd and picking out your friends. In other words, just really nitpicking what fits you best. Kaplan then concludes that legislative history of the HEA sheds at best an inconsistent light on what Congress meant when it directed the department to provide Title IV funding to only schools that prepare students for gainful employment in a recognized occupation. Moving now to part 3 of the opinion, in terms of the Administrative Procedures Act, the question that the court needed to determine is, did the record show that the agency examined the relevant data and articulated a satisfactory explanation for its actions? Only if the court finds that a clear error in judgment or the agency relied on factors that Congress did not intend to consider should a court vacate the rules. Agencies must give ample latitude to adopt their rules and policy for the demands of changing circumstances. Here, Judge Kaplan ruled that APC utterly disregarded the extensive statistical analysis underlying the GE rules. Kaplan acknowledged that the department conducted a series of multivariate regressive analysis before promulgating the final rules. He even agrees with Judge Contreras here that, again, that the department went through the necessary procedures to listen to everyone that was out here and commented on the rules. Further, that the department actually made a reasoned analysis and a reasoned basis and then was able to defend it, and that's technically all that they needed to do. Here, Judge Kaplan said APC misunderstands the purpose and limitation of the department's information quality guidelines, which basically were strictly guidelines to improve the internal management of the department and don't create any private right of action to be used against any parties against the government in court of law or administrative hearing. And again, the department's information quality guidelines were simply guidelines for the department to follow and not necessarily had a rule of law or that could be used against the department. Moving forward, finally, APC also mentioned that the rules were arbitrary and capricious. However, Judge Kaplan determined that no, they were not arbitrary and capricious because first, it is not inherently problematic for an agency to change its position. To get into a federalist or a government debate, it was almost as if Judge Kaplan believed that the agencies were able to move faster than what Congress could do, and so therefore they would be able to adapt to the changing circumstances more favorably to the people. Second, there was no dramatic change that APC argued, where essentially this policy was and regulations was essentially a change in name only, because there was no settled rule to which institutions were expected to adhere to, and institutions did not actually rely on them. Specifically, arguing that the 2012 litigation, 2011 rules, there was such a change from there, but those rules were never promulgated. They were never enacted because of Judge Contreras' opinion, which vacated those rules. And then finally, third, in terms of arbitrary and capricious, the department did provide that adequate reasoned explanation for changing those thresholds, which is all that they needed to do to promulgate the rules. In terms of a timeline, APC has already come out, and they said this on the 27th when the decision was made, that they will explore all options, and including any claims of appeals, as well as any influences on APSCU. APSCU remains confident in their legal position, as the two cases were substantially different. APC does have 60 days to file their a motion of appeal. However, an injunction or a stay for the rules would likely, I suspect, would be asked for contingent upon the outcome of the APSCU litigation. How does this affect APSCU? Since Judge Kaplan ruled before Judge Bates in the APSCU case? Well, first of all, almost immediately the Department of Education filed a notice of supplementary jurisdiction with the DC Circuit, asking Judge Bates to consider the ruling in New York. Likewise, the next day, APSCU followed that up and countered, basically saying that the case should not have any bearing on DC Circuit because the cases were dissimilar and the opinion leads to no additional support for the department. Specifically, the primary issue for APC was a due process claim, whereas APSCU never really advanced that claim. Second, where Kaplan relies on Judge Contreras and Gainful Employment 1.0 for statutory authorization, that decision is not binding on Judge Bates, and that's a conclusion that even the department does not contend. Specifically, where Judge Contreras did vacate those rules, essentially it was a 2-to-1 decision, and that one part that APSCU would have lost, if you will, was that one aspect of what Kaplan relied upon. And then finally, third, Judge Kaplan's decision is highly generalized and did not discuss the specific grounds that APSCU raised.